Oh, good. Oops, I don't have screen sharing. Should say Katie McBenn, Office of Legislative Counsel. Still don't have screen sharing.
Morning, Coach. Pay attention to the road.
Morning. Yep. Yeah, I'll close the sun visor, so I'm not looking at the sky.
Go ahead and, well, I'm going to have Panina mute you, so.
Okay.
Okay.
So the last time we met, when we looked at S89, just to remind you, this is the forensic facility bill. It was a much longer bill. It was about 30 pages, and it had a lot of admissions criteria, commitment criteria around involuntary medication. So it created a whole process for how individuals who are in the custody of the Commissioner of Mental Health or the custody of the Commissioner of Dale could apply to have people treated in the forensic facility and who would be appropriate for that facility. So much of that specific language is absent from this draft. And instead, we'll walk through the legislative intent. But the idea is that there's sort of work that is done between now and the next legislative session to prepare for looking at that more sort of substantive language about admission criteria and procedures. So what remains is we have a new legislative intent section. It is the intent of the General Assembly that an initial forensic facility be authorized. Did I say General Assembly? Is the intent of the General Assembly? I heard myself say facility. That an initial forensic facility be authorized and operational beginning on July 1, 2024, in the 9-bed unit of the current Vermont Psychiatric Care Hospital. This unit shall be relicensed as a therapeutic community residence. In preparation for the operation of a forensic facility, the work of the General Assembly in relation to this act shall guide the Departments of Mental Health and of Dale in adopting rules and the working group established pursuant to Section 6 of this Act and recommending procedures and criteria for commitment of individuals with developmental and intellectual disabilities. And then,
can I ask a question? So the word initial, does that mean that we anticipate more than one?
Potentially. The way the language was drafted, it was a forensic facility was, somebody to a instead of the. So this potentially foresees that there could be more than one at something.
And then to a forensic facility in the last sentence doesn't necessarily mean the initial one I'm taking. Right.
So when we're talking about that the working group is going to look at procedures, the procedures that would go in the green books, presumably, would be sort of the same language, a forensic facility. So if somebody is admitted pursuant to those procedures, it could be any forensic facility that exists if there are more than one.
Okay. But we're not, by that legislative intent, authorizing multiple ones. Like, it's not, I just want to make sure we know what we're giving intent to.
Yeah. So first, legislative intent is aspirational.
Right.
So just keep that in mind. But right here, you're saying that the current thinking around a forensic facility is that we'll have one in a unit of the Vermont Psychiatric Care Hospital. But this certainly doesn't preclude anyone from actually having it be somewhere else or having more than one in the future. Yeah.
Okay, thanks. And I have one other question, which is, we already have a category for licensing that's called the therapeutic community residence. So that's an existing license that mental health does, or licensing?
Dale has, Dale is the responsible party for therapeutic community residence. And for example, the Middlesex, the Secure Residential Recovery Facility, is licensed as a therapeutic community residence.
Because I know like DCF also, so I just wanted to, it would be the Dale one that would, yeah, okay.
Yeah, it would be Dale that would regulate a therapeutic
Yes.
community residence, but just like with the secure residential, which has individuals in the custody of mental health, there can be individuals who are not in Dale's custody who could be,
Yeah. Okay, thank you.
yeah. And then we have certificate of need language. The last time you saw this, we had sort of a broad exemption for any forensic facility ever, not to have to go through the CON process. So per the recommendation of the healthcare committee, this has been narrowed down to just this initial 9-bed unit under consideration. So notwithstanding any law to the contrary, DMH's establishment, actually, we should maybe change this to DMH and Dale. I had changed it when we were thinking of just striking the Dale language from the bill. Establishment of a 9-bed forensic facility within a unit of the existing Vermont Psychiatric Care Hospital is excluded from the CON process. So this is just an exemption for the initial facility under consideration.
I apologize because
Okay.
we only
Okay, I'm
have
sorry.
Katie for 11 minutes, but we're
Okay.
going to try to get her back
All right.
at some point, maybe later today if you have her in your,
Yeah,
so note your questions
All right,
and
will do.
we'll definitely circle back around to Katie.
Okay, and I just noted to add Dale back in that CON section. Okay, and then we have rulemaking language. This is the same language that has been sort of moving with the bill since you've had it from the Senate. So this requires that rulemaking is initiated July 1, 2023, of course, not finished, just initiated. And so the first rule that would be amended would be the Dale rule on therapeutic community residences to allow for the use of emergency involuntary procedures and the administration of involuntary medication at the forensic facility. Because right now those are not allowed in therapeutic community residents, hence the need to amend the rules. And similarly, directing DMH to amend its rules on administration of non-emergency involuntary psychiatric medications to allow involuntary medication at a forensic facility, because right now involuntary medication for individuals under the custody of the Commissioner of Mental Health is only allowed in hospitals. So in order to use involuntary medication at the forensic facility, they need a rule change, or a rule amendment. This section 4 is also the same, since it's come over from the Senate, that by February 1st of this coming year, AHS is to present the following information to the policy committees. That is a plan for staffing and programming at the forensic facility, including whether any specialized training will be required for staff members and whether any services provided at the forensic facility will be contracted to third parties, and whether any additional resources are needed for the operation of the
Very quick.
facility.
Okay.
I'm just wondering why Judiciary Committee wasn't on Section 4 report, because that might be useful information as we take this up again after the Section 6 report.
Yeah, it doesn't hurt to add us.
You want to be on the 4? Okay.
Thanks.
And H2. Okay.
Probably should add Senate Judiciary to that too.
Yep.
Maybe you have the same feeling about Section 5, which is a report annually on the forensic facility. So this would be an annual report on January 15th of every year between the years of 2025 and 2030. We had the DMH, again, I had stripped out Dale when I thought we were just moving the mental health language, so we could add
Yeah, and add
Dale back in.
the judicial committees as well.
Okay. And so we have the reports coming in a 5-year window from the departments to policy committees, containing the average daily census of the forensic facility, including trends over time, the number of individuals waitlisted for the forensic facility, and where these individuals receive treatment or programming while waiting for a bed at the forensic facility, aggregated demographic data about the individuals served at the forensic facility, and an account of the number and types of emergency and voluntary procedures used at the forensic facility. And then we have new language. This Section 6 creates a working group to really focus on the admission and criteria language around the commitment of individuals who are in the custody of the Commissioner of Dale to the forensic facility. So there is created the working group on policies pertaining to individuals with developmental or intellectual disabilities who are criminal justice involved. The working group shall assess whether a forensic level of care is needed for individuals with developmental or intellectual disabilities who are charged with a crime of violence against another person, have been determined incompetent to stand trial, and are committed to the custody of the Commissioner of Dale. If it is determined that that forensic level care is needed for such individuals, the working group shall propose legislation establishing the process and criteria for committing such individuals to a forensic facility. And then we have the membership of this working group. First, an employee of Dale who represents the public guardianship program or who is a public safety specialist. A representative appointed by the Disability Law Project of Legal Aid. A representative appointed by the Developmental Disabilities Council. A representative appointed by the Green Mountain Self-Advocates. A representative appointed by Vermont Care Partners. A psychologist with experience conducting competency evaluations under Act 248, appropriated by the Vermont Psychological Association. 2 individuals with lived experience of developmental or intellectual disability, one of whom has previous experience in the criminal justice system or civil commitment system, or both, appointed by Vermont Legal Aid. A family member of an individual with a developmental or intellectual disability who has experience in the criminal justice system, or Act 248, appointed by the State Program Standing Committee for Developmental Services, a representative of the Vermont Crisis Intervention Network, the Commissioner of Dale or designee, the Commissioner of Mental Health or designee, Commissioner of Corrections or designee, Executive Director of Department of State's Attorneys and Sheriffs or designee, Defender General or designee, 2 members of the House, one from Human Services and one from Judiciary, 2 members of the Senate, one from Health and Welfare, one from Judiciary.
Very small comment. I'm worried a little bit about the power dynamic of this makeup because we have the commissioners of 3.
Well, let's talk to the.
Okay, talk later. Got it. Okay, cool.
Yeah.
So next is the powers and duties of this group. The group shall assess the need for a forensic level of care for individuals with developmental or intellectual disability, including the extent to which a forensic facility addresses any unmet needs or gaps in resources for services with developmental or intellectual disabilities, the specific circumstances under which an individual committed to the custody of the Commissioner of Dale could be placed in a forensic facility, improvements to address concerns with the due process for individuals subject to the custody of the Commissioner of Dale in a forensic facility. I don't know if I like that on line 16. I might strike it.
You'll play with that language a little bit.
Yeah.
Okay.
Subdivision 4, line 19. The roles of Vermont Legal Aid, an ombudsman, or Disability Rights Vermont in serving individuals with developmental or intellectual disabilities placed in a forensic facility. Subdivision 5, necessary changes to 13 VSA 157. That's our language of individuals sort of coming in through the criminal justice door. 18 VSA Chapter 206, individuals coming in through to the system through the civil door. And then we have subdivision 6, investments, policies, and programmatic options for high-quality community-based supports for at-risk individuals committed to the custody of the Commissioner of Dale. Assistance, the group will have the administrative, technical, and legal assistance of Dale. Report, by November 17th of this year, the group shall submit a written report to the various policy committees with its findings and recommendations for legislative action, including proposed legislative language. In terms of meetings, the representative of Dale should call the first meeting to occur on or before September 1. I should just flag, now we have 2 representatives, Dale, because we have subdivision 1 where it's the person with experience and we have the commissioner. So we need to clarify who we mean here.
Yeah, we'll revisit that.
The committee shall select a chair from among its members at the first meeting. The majority of the membership shall constitute a quorum, and the working group shall cease to exist December 1st of 2023, 2 weeks after the report is due. Compensation. So we have sort of standard language that members of the group who are not otherwise compensated for participation in the working group shall receive per diem compensation and reimbursement for not more than 10 meetings. And that those payments are made from monies appropriated to Dale. And then I pulled the definition of forensic facility from the bill that we had been, the definition we had been working with, and I added it here. So we're clear what we mean when we say forensic facility. And then we have this taking effect on passage to allow a little lead time for the appointments to the group to occur. And also we have a July 1 initiation date on rulemaking. So an effective date on passage gives a little runway there.
We have you for 2 minutes, so if there's a 2-minute question, or we can give you 2 minutes to take it to your next place. How about that?
Either is fine.
I will ask one of my questions. So one of the things that we were hearing from some of the witnesses was people might be receiving or be able to receive, or it's desirable to receive services from DOC. And I'm just wondering if anywhere in the working group tasks, because we talk about like unmet needs and policies related to the forensic facility, but I wonder if on the table should be anything that Department of Corrections needs to implement or think about, because it's possible that we will hear of things in that bucket.
I understand, yeah, I remember the testimony. I have a feeling that would broaden this. I mean, I don't disagree that should be looked at, but should this be a little bit more focused, even though we do have the last provision, number 6, which is much broader, but focuses on community-based supports.
And maybe it's like including other state service. I mean, maybe something that just.
So let's ask the witnesses.
Okay.
For that. I think that's a question for the witnesses.
And super quick, is the people on this group don't match the committees that are getting the report, and I don't know if that's an issue. Like there's no one from the House Health Committee on it, and I didn't know if that was deliberate.
But that was deliberate because it's Dale focused.
Right, but they're getting a report on
Yeah,
this.
yeah, I think they should still get a report.
Okay, just
I did talk to Lori about that this morning, so I think we're fine on that. So, Coach, we're losing Katie in 1 minute, but go ahead with your question. You have to unmute yourself. You're muted if you wanted to weigh in or have a question. Or you can ask the question this afternoon when we have Katie back, because she has to leave, actually.
Unmuting while driving is sometimes treacherous.
Yeah.
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 Well, it wasn't a question for, can you hear me?
Yeah.
If it's not a question for Katie, can you hold it for just a second? Because Katie has another obligation in 30 seconds ago.
It's an addition to the language. We took a lot of testimony around the licensing of the professionals, and I just thought that does it make sense that we add the Office of Professional Regulation to the working group so that, as Vermont changes its regs for determining competency, it's already in the mix? Just a question.
Yeah, I don't think this is, well, we'll leave that question for the witnesses as well. So that is a question, and hopefully Stuart and Karen heard that question and can comment on that, as well as what we have here in front of us, which I will say up front is different than what was sent to us on whenever that was sent to us, and I can't remember, Friday, Monday, I guess it was. Thank you, Katie. And if you could just let me know, like, when you have other time slots that you might be.
Okay. Okay. Yeah, that's nice.
Thanks a lot. All right. So I'll, Karen or Stuart, who would like to go first and on weighing in? Well, Karen was quicker at coming on the screen, so I guess we'll start on Karen. Sorry, Stuart.
Thank you. For the record, Karen Barber, General Counsel of the Department of Mental Health. I kind of have just an overall question. So it is a little different than what we had proposed, but my bigger question is all of the statutory changes that would allow us to actually use the facility are gone. DMH can't actually utilize a facility like this without all of that language that allows us. DMH is very limited in where we can place. And so I'm just wondering why all of that came out.
All of which came out?
So it looks like it's a strike all, unless I'm misreading it. All of the sections that talked about the orders of non-hospitalization and the hearings and the orders, all of that stuff is gone.
So that was my understanding on Friday, that was the desire of AHS, because they wanted all or nothing. And the proposal I had on the table was to keep the DMH language in and then add this working group for the Dale part. But as I understood it, that was rejected. That was not the choice that AHS wanted. So that's why we went this route. And if I misunderstood, we can see if we can get that language in and with enough time to go over it.
Okay. So the idea would be that we would kind of just continue to plan.
I think that the idea, I think as well, is that I believe that the language in DMH components, those sections was pretty close. And that's going to continue, but I thought the concept was as well that if something comes out of this working group on the Dale side, that language might have to change, and that's why we took that out as well.
Okay, okay, I can hear that. That makes sense. I do wonder then, we had asked for some flexibility around the rulemaking then, and I do think that's kind of a key component then. I think we can go ahead and start to amend the involuntary medication rule. We had asked to start that, I think, in August, just to give us a little bit of breathing time after this session. But we had asked for the amending the rules for the TCR reg to kind of start to begin to draft in September so that they could be done in conjunction with the working group. It's going to be really hard for us to try to file something in July. One, because it's going to require a lot of work and we need time to kind of work through that. And two, I think some of the reason we wanted some flexibility is because we were hoping to know what was going on with the Dale group and then try to merge those. And ideally, instead of trying to propose the rule twice, to try to have one rule going forward.
So yeah, I mean, we can adjust dates here. So for instance, jumping ahead, the working group starting September 1st, I'm going to suggest an earlier date that the working group, like mid-July. I know it's summer, but so I was going to suggest that. And if we need to then also move back the start of the rulemaking. But let me just make sure I understand that the contents of the rulemaking is fine. It's the dates that, because I think this is what we've had for a while, but if there's changes to that.
Yes, we hadn't kind of, because we were trying to see how everything played out, we weren't worrying about the time frame of the rules. The time frame of the rules was probably always a little unrealistic from our perspective, but we were just kind of letting it play out until we understood what the legislature was going to do, and then to try to figure out what was workable in terms of the rule dates. So what we had asked for was that on or before August 1st, we file about the non-emergency and voluntary psychiatric medications, and then on or before September 1, we begin to draft proposed amendments. So not actually file, but begin to draft them. So they're in draft form so that we're ready to file once we understand exactly what we're filing.
So can you provide language that gets to what you just said? I don't see that that's a problem. I mean, we want to work the timing of this, all kind of aiming to July 2024, although I do understand there are questions from corrections that may need to be dealt with, but that's a little separate from right at this moment.
Yes. Okay. So I can definitely email that language to you. I guess I I don't know if I had. The only other thing we had also asked for, and I'd like to kind of put back on the table, was just some flexibility around the location. So I think the House Corrections and Institutions has heard a lot of testimony. I think they do have some concerns about it being at VPCH. What we talked about was, is there some flexibility that it could be at the way we had proposed some languages, that it could be at VPCH, but it could also be at a secure residential designated by the commissioner. That gives a little bit of flexibility. I think part of that is if when we talked about the 9 beds, and the reason we thought 9 beds was a good number is because we were talking about 2 different populations. If there's a policy decision to take out one of the populations, we want the flexibility to think about, because we can't just take 5 or 4 of the beds offline. We have to take all 9 because of the way the facility is organized. We couldn't mix within the wing. And so we talked about having some greater flexibility so that if it was going to just be mental health, we may think about utilizing a different space to not take all 9 beds offline. So we were hoping we could have some flexibility around that.
Yeah, I don't personally have an issue. I think that that's something you need to take to corrections and institutions. I do understand that later this morning, they're going to be working with Katie on whatever their concerns are, which I haven't delved deeply into because it's kind of out of our bailiwick. But that sounds like the kind of issue that should be worked out with them.
Okay.
I don't think this committee is as concerned about where and what it looks like. It's just the due process and criteria that we're focused on. So,
okay.
Ken has a question for you.
Good morning, Karen. I noticed from the last bill we had 26 pages, and now we're down to 9. So I assume there's a lot of stuff that's changed around that you're well appeased upon and know what's going on, because I don't, and I got to really look at this.
So that was my initial question, was where was it all? It sounds like the idea
It went
is
poof.
to hold on some of that and then to pass it ideally. DMH still believes, and the Agency of Human Services still believes, that the 2 populations should both be served in this facility. Again, that we should stop siloing care, that we should understand that these are complex individuals, often with dual diagnoses, and that, again, Vermonters would be much better served by having a facility that could actually meet the needs of the population we're trying to serve. However, we understand that right now that is not going to pass through the legislature. So it sounds like the idea is that you're going to give us a little bit of time to kind of try to do that as a package as we start to move forward and start to plan and implement, so that we can hit the ground running in July, I think 2024. I think that's what I'm hearing. Ultimately, that language will have to go back in. But if it's next session as opposed to this session, it wasn't going. We didn't need the language right now, I guess, because we weren't going to admit someone right now anyway, because it would have had to wait until July. So if that answers your question.
Well, it does, but we're still going to have people in a big need that we're still dealing with the same stuff that I've been here for 5 years that we're not dealing with.
It does mean for another year, yeah, there will still continue to be the gap in the system.
And that's what we've been operating under since we received the bill over from the Senate, was a July 2024 start date, because there are facility issues that still potentially need to be worked out. There's the rulemaking that has to happen no matter what, which takes a bunch of time. So we're going to use the time that we have to make sure we have the process and criteria right. And certainly, I think going into this, the assumption, at least that I'm taking in looking at the language, although we still are going to ask and answer the first question of whether a forensic unit is appropriate for the developmentally disabled. That is part of the question, but there's, at least from my perspective, there is a population, and it could be very narrow, of somebody who has a developmental disability, that the best place could very well be a forensic unit. But then again, we're going to let this group work on that. And part of the, the issue was, and we did have on the table, Ken, that we would have done the DMH side of it and would have worked on the Dale side in the interim, the next 4 months, 5 months. But we heard from AHS that it was preferable that it all kind of work together because they need to work together, the process and criteria for both populations. So that's why we're taking this approach. And we've gone with the work group with legislators on there with a requirement for draft legislation as well to make sure that we're continuing on the momentum, that is the goal. So again, the idea is still to have all this process ready to go once there's an actual facility ready to go.
Can I just ask you a question?
Yep.
So where are those people with the disabilities, where are those people going now? I can't remember.
You'd have to ask Stuart probably on that.
Where are those people going that we're having one of the main concerns, I think, with this bill is the people that is disabled. Where are we able to help them the most now without this facility?
Well,
I'll defer to Stuart.
Sure. For the record, Stuart Scher, General Counsel for the Department of Disabilities, Aging, and Independent Living. So, as I mentioned last time, I believe the options for Dale at this point are quite limited. We have community-based options as the only for placing individuals who are put into the custody of the Commissioner of Dale. That means, in most cases, it means staffed homes in our communities. And while that model works incredibly well in the vast majority of cases, there are very few in which we don't have the ability to meet the needs of the individual or to adequately protect the community. So that's why we're arguing that this needs to be addressed as quickly as possible, recognizing that the committee does want to pump the brakes a bit and give everyone an opportunity to weigh in on this. But that is our position. That's been our position. We just don't have adequate options for the very small number of individuals who present an extremely high risk of harm to the community.
Well, we haven't, I mean, I'm not even going to say it, but it sounds like we have an opportunity to really to do something here. And it sounds like I'm getting major pushback for something that I just don't understand. But I guess that's a world of politics that I really don't understand.
So did you have more, Karen? Did you want to talk about the working group, or should we jump to Stuart on that?
One question.
Oh, yeah, before you go, sorry.
Yeah, one question before we go there, and it's, I don't know if it's for Karen or Stuart, but the language, all the language that was removed from here that we're going to have to, if everything proceeds, the way we hope, I guess, we're going to have to take up next year. And bring everybody back in and get testimony, from witnesses and all this and that. So my question is, do you think because we're going to have to go through this whole process again, it's going to push us past the, what was the date? The July 1st, 2024 date?
So that actually was kind of my, so I just wanted, what I'm hearing is that DMH and Dale are kind of need to start actively starting implementation planning for the facility as drafted in 89. It doesn't mean it won't change, but I think our marching orders right now are to plan as if it is going to be what is proposed and that we start implementing those plans. Is that?
So I mean, I'll also just add to that the concept is that we will have legislation to start looking at here on day one when we get back. And it'll be legislation that I'm very much hoping everybody's on board with, and that it covers both the Dale side and the DMH side. And we'll move this as quickly as we can over to the Senate, and we'll try to get the Senate to move even before crossover, so it'll be in place. The goal again is July 2024.
Right. Yeah,
just to get it right as well.
Right. Yeah, it's just my hope that it doesn't get pushed out even further, but I want to thank both of you with your patience with the legislative process here. So
So the other thing I'll just note again, just to make clear, and it will be a question I will put out there, is that we have in the legislative intent that this act, meaning S89, is something that should be looked at as this working group proceeds. In other words, we're not throwing out all the good work that we've done in the legislation so far, and I'm anticipating that will be before this working group, perhaps even as a starting point. I don't know that we need to be even any more specific about that actually in the bill, because I think that we're putting that understanding out there. Are you good?
Yeah. Well, kind of.
Yeah, kind of. Right. So Karen, did you have more? Should I jump, or at least at this point, or should I jump over to Stuart?
I would just say one thing about the working group, and this is I'll defer to Dale on most of it, but just lessons learned from the DMH perspective. One of the things that we had proposed to you in language was, as opposed to doing a working group, having a requirement for a plan with consultation. And the reason we did that is because we've had working groups and we're concerned that it's not the best format for providing a specific work product, and that there are other ways to ensure that a product does come forward and that you're hearing input from everyone. So, just from experience from the forensic work group, I think it wasn't as successful as it could have been. Because we were trying to plan as a group, as opposed to kind of having something that we were starting from and then asking for input. I think that maybe would have gone a little better. So that's why we proposed that language. However you want to go about it, that's just kind of a lessons learned from our perspective.
Absolutely understand that. And the two things that I've tried to incorporate into here to address that. One is that we have a starting point, which is the language that we've been working on this session, that we have a somewhat narrower range of what we're looking at. It's not just, it was really broad last time. I mean, I think the directive. And I do think, I hate to say it, but I do think that having 4 legislators on this group in the committees of jurisdiction who are committed to getting this done will also help. So those are the things we've done. I recognize that. I do wish that we didn't have such a large group, and would be welcome suggestions on who we might not need to have on there. I think having 2 people from Dale already, we need to decide on that issue, but it would certainly take recommendations.
How many total is it right now?
It's like 19.
I was gonna say, yeah, that's way too big. We need like 7 or 9.
Yeah, well, I mean, we can ask whether we need to have state's attorneys and defender general, but I assume that we do. So I very much would like to hear input on who's in here, as well as the tasks that we laid out, which we tried to mirror from what you had in what you provided. We tried to certainly follow that as much as possible, but also looked at what we received from the human services. So anyway,
Just something that's on my mind with the size, the size of the board or panel, whatever you want to call it, is, and make food for thought. Nothing that's got to be answered right now, but would some of these people make more sense as a witness other than as a member?
Right. That the working group must consult with.
Right.
That's a possibility. We can hear what folks think on that. And we have some people coming in this afternoon to testify.
Right. Yeah, because I mean, I've seen it a lot through the years when you make these, these boards too big, slows things down, and a lot of times decisions don't get made.
Agreements are hard to reach.
Absolutely. Yeah, I understand where you're coming from on it. That's my biggest concern with the working group is its size. All right.
I think that's all I have now, unless people have questions.
All right. Thank you, Karen. Stuart.
Good morning. Thank you again. Yes, I guess there are a few points I wanted to make this morning. The first is that I'm a little unclear on the new legislative intent and how that jives with the working group model. And the only reason I bring that up is that from the legislative intent language, it appears that the facility is contemplated to be available for individuals who are placed in the custody of the Commissioner of Dale under Act 248, but subject only to the procedures and the criteria that are established in Section 6. But yet, then we go to Section 6, and the first question there is whether the forensic facility is needed for individuals. So I'm just hoping, maybe I'm misreading this. I just got it this morning, as did you. So maybe that's not an issue, but I was wondering what the intent truly is, and is it contemplated that after the parties meet in response to whether it's a working group or some other model, that there is an understanding that it will be utilized for that purpose for certain individuals, subject only to those limitations that are decided upon at a later date.
So the way I read this, and I wanted this kind of intent in here, is that, yeah, our intent is that we have a facility that accommodates both. But there is this first question that could halt it all if this working group hears such testimony that there's another way besides a forensic facility, that would put a brake on that part. But I think certainly from I believe reading this committee and certainly reading other committees, that's the intent. That may not be the intent that was reflected in the suggestion of Human Services Committee. But I think it strikes a balance that, given what we've heard from AHS, that very much they want to have it this way. And I think there's a lot of support here for that, but we want to have that kind of that ability to put a brake on if that one question. I think we do owe it that we need to look at that first question in the working group as well. I don't know if that made any sense. I'm trying to navigate this one, thread the needle.
I appreciate that. And I think the intent that I'm hearing from the committee is clear. I just wanted to make sure that I was understanding what that was. So thank you for that. I guess I'll just echo what Karen finished with, which is, first of all, this is clearly not what the agency submitted as its proposal. And there is some concern with the creation of a working group. Karen, better than anyone, can talk to the lessons learned of the forensic working group and the tribulations that they had to deal with. The message that I want to send is that these are complicated issues, and we appreciate that there's a desire to hear from all of the interested parties. But it's also critical that the input that's provided, however it is in whatever forum, that it's tailored to the issues to be addressed. And it certainly is not the intent of Dale, DMH, the Agency of Human Services, to quell any input. We would, in our proposal, which is to consult with a broad range of individuals, and then to have Dale responsible for submitting the report, we would include in that report all the information that we solicit from each of these listed individuals. We would accept that and we'd include it. And any of those individuals and all of those individuals would have an opportunity to speak to the report come the beginning of next session.
So can I just jump in right there? Sure. Just following Tom's suggestion as well. I still think we need the working group. I really think we need to have legislators on this working group, because the idea is to get to the point of having an introduced bill. It doesn't make sense for legislators in the other way we set it up. But if we can have a narrower working group with a requirement that certain other entities are consulted, and that doesn't mean that I would eliminate all of the various representatives. I still think we need to have some of the developmental disability, like the Developmental Disability Council, perhaps, or we need a couple of those voices in the working group. And then move a number of these other individuals to consultation. That may help as well, given the experience that the forensic working group had. And I think that, may address yours. So if we can consider where we would move people into that consultative role from this long list.
Sure, and I would think that with the representation of the Developmental Disabilities Council and the Green Mountain Self Advocates, who are in fact individuals with developmental and or intellectual disabilities, we have a representation of that perspective. I would hope that those entities or the individuals they appoint would be able to consult with individuals with lived experience, for example. If not in their entirety, then it seems that having two individuals with lived experience might be is an area that could be relegated to a consultation role, as well as a family member of an individual with developmental or intellectual disability.
Yeah, and we could even expand then that we would be talking not just two individuals, but individuals with lived experience and family members. So I would suggest, well, just going through, why don't we go through the list and just for an initial pass on this, and I know we have some more testimony this afternoon. We still need to decide whether to have Dale commissioner or what we have as listed number 1. And I know that Joe had a concern about that, but maybe not so much if we're narrowing the group in the consultation. Or what was your concern?
Yeah, I mean, sort of the concern was, again, we've been talking for a few minutes about sort of some of the challenges of the initial group, that commissioners hold a lot of water, they're powerful individuals. And I worry about the power dynamic that could exist when, you sort of have, folks who may have one perspective and then a commissioner who has another perspective, and there's a real power imbalance in that. And so I want to ensure that when we're talking about folks with lived experience, that, they're certainly have that voice, that vote, that power, because I would hate to see us here, in 8 to 9 months, and then hearing testimony again that we feel that our voices were ignored, we feel that we're not getting what we want out of this. And so, I'm not opposed to commissioners being on it, but at the same time, I worry about, having 3 commissioners on something like, it could be, yeah.
So the only thing is that I'm assuming that given past working groups that there will be designees, but
I assume that's
we can ask, Karen has her hand raised on this.
Sorry, you asked that before and I forgot to answer it. Yes, I do anticipate that it would be designees on the forensic work group. There wasn't commissioners that actually did go. It was designees so that people could have those conversations. I don't think we heard any sort of concern about that, but I think that's a valid concern of yours. But I think in practice, it doesn't play out that way. They generally just designate the best subject matter expert. So for DMH, it was me and a couple other people. I assume this will be Stuart and a couple other clinical folks.
Great. It's helpful.
Yeah.
Thanks.
So I think that we can eliminate number 1 because it will be somebody designated from Dale anyway.
The only thing, Mr. Chair, the only thing that I would say is that there may be, because this concept does touch so many aspects of what we do at Dale, having one person may not we may not be able to identify one single individual that can represent all of those interests. For example, we have what's listed here as someone who represents the Office of Public Guardian or a public safety specialist. The public safety specialist has probably the best knowledge of individuals who are placed in the commissioner's custody under Act 248. But as Karen noted, she was a participant on the forensic working group, and I expect to be needed to address certain aspects of this as well on behalf of the department. Unless I would be included as the legal support for the department as contemplated in the, I'm trying to see what section that is. In D, subsection D, the assistants shall have the legal assistance of Dale. Then I think that there would need to be, in order to adequately speak to all of the issues, at least one other person from Dale.
So I would think that you would have a Dale designee, and if there are specific issues that are coming up, that person's brought to the table to address that specific issue, but there's one main person for Dale, is how I would see that play out, because that can, in other working groups I've been on, there's been one designated person, but they are free to bring in their expertise when needed for the conversation.
Okay.
So I am trying my best to narrow this now to a workable actual working group. So representative of the Disability Law Project, should that, I know you mentioned the Developmental Disabilities Council and Green Mountain Self Advocates. Is there a problem with having, not is there a problem? I'm trying to narrow this, but so I would think we could keep them. We could keep Development Disabilities, the Self Advocates, Vermont Care Partners. We can put them in the consultation realm. Is that?
I think it's important for them to have a seat at any table because they're the entities that are serving people currently.
Yeah, that's fine. So we'll do the psychologist, number 6, should be consulted. The individuals with lived experience will consultation. Family member of individual consultation. How about Vermont Crisis Intervention Network?
Again, I think that's important for them to have a seat at the table to talk about the resources that are currently available and how they're utilized in the current system.
All right. So I assume we need mental health corrections and Dale. Do we need to have at the table, I assume, the state's attorneys and defenders? I don't know that we necessarily.
Yeah, I'm not sure. I'm not sure that that's necessary given the scope of what we're looking at here.
Yeah, I think they're in the consultation realm. And then we have the members from, I think we do have to have 2 House and 2 Senate. So we've narrowed it down a little bit. It's 1, 2, 3, 4, 5, 6, 7 people less. A little more doable. So we'll have Katie draft language that says, they shall consult with these entities, and we can find out this afternoon if there's additional ones that we want to put into the required consultation. So hopefully that solves that part of it. If we want to move on to the powers and duties and any input on that. Again, we tried as much as possible to match from what came over from AHS on Monday, though slightly adjusted it relative to the Human Services recommendation that we received. But happy to hear some comments on that part as well.
Sure, and I'm not sure if it's included in that section, but I've seen it in a few places in section 6 where there are references to both individuals with developmental or intellectual disabilities. And I really want to be clear that the current Act 248 framework is available only for individuals with intellectual disabilities. So I don't know if we need to examine specifically whether a forensic facility is appropriate for individuals with developmental disabilities. We are not proposing that those individuals be considered for placement in the facility.
All right, so I will defer to the expert. I mean, if we're not looking for the forensic facility for that, then we should probably correct that.
Yeah, I see that in several places in the powers and duties.
Well, I mean, if we're, but.
Right. I mean, but this opens up more than one, right? Wait.
Well, but if we're not talking about developmental disability, somebody with developmental disability going into a forensic unit, period.
We think.
Well, if we don't include them, then they're not included.
That's true. That's true. But if the feedback comes, I mean, we're cutting off certain avenues to the feedback that we're asking people to give. And it's like, so I just want to make sure when we hear from witnesses that people feel okay about what's off the table.
Yeah.
That's all.
And
Like,
they don't
yeah.
want anybody, a lot of the stakeholders don't want a forensic facility for any of them. So,
Right.
I think,
yeah.
but we can, note that and certainly have, other witnesses comment on it. So, I'll note, I'll circle that, the development. I think actually, if I'm not mistaken, that this was a suggestion from the Chair of Human Services. So, but I will circle around with her. All right, so I have that. I think I found the instances where we had that language.
All right, in subsection C3, I think Katie noted that she was going to either strike that or reword that. I think it presumes that there are concerns with due process at this point, and I think that that's certainly not our position. We believe there is more than adequate due process here, and so the presumption that there are concerns that need to be addressed for individuals subject to the custody and simply under Act 248 is one that I think could either be deleted or at least reworded so that we're not going into this with a presumption that there are problems.
No, that makes sense, and we can. And I know that the recommendation from AHS did have some language related to due process, so I'll just double check what was said in that recommendation.
Okay. And I think we proposed some alternative language around due process if you want to consider that.
I think that, that's what I'm going to look at from what.
Got it. Yep. And then in subsection C5, there's a reference to necessary changes to chapters 157 and chapter 206. And I'm not sure what necessary changes mean. Is it simply changes that need to be made in order to allow an individual to be placed in a forensic facility, or would it also include those other sections, for lack of a better term, the housekeeping provisions that Dale proposed that have been removed for changes to Act 248? Those, some would argue, aren't necessary, but they're certainly helpful to a smooth operation of the process.
All right, so 1 second. Okay, it's slightly different. The language we received from AHS was consider whether any changes need to be made to 13 VSA Chapter 157. So we can adjust that language somewhat. So it's not like presuming. I mean, the idea is that, give us a proposal of any necessary changes.
I see.
I don't think that different from what we received. Consider whether any changes need to be made, and we're asking for a recommendation of necessary changes. I think that's pretty much the same thing, I think. And on the due process part, bear with me, I'll find it. Consider any concerns with the due process for individuals subject to commitment to the custody of the Commissioner of Disability, Aging, and Independent Living. That's how that was termed there, but we can adjust that so it's not a presumption, but that we are looking at due process.
Okay, thank you. I think that might be all that I have. Anything else for me as far as the powers and duties section?
All right, so I would jump to the page 7, line 17, the date of September 1st. What is a reasonable date for this work to commence? Because I think that's too late. Is it mid-July? Is it the beginning of July? Do we celebrate the Independence Day? Do we do it 10 days after this passes?
Oh, no, a day.
I'll defer to you on which day, but July seems reasonable. And if you want to pick the 1st, the 15th, or somewhere in between, that would be fine.
All right.
I do think start the work.
We'll go with July 10th. which is the Monday after the 4th of July week where people might not be around.
All right.
And anything else as far as just the setup? I know that one thing that might happen when this goes to appropriations, and it's possible that government operations is going to do a very quick drive-by. But in appropriations, they may ask, well, how many meetings are you going to need? They often require that. And I was going to suggest 10. I just pulled that out of the air. And if we need more or less, suppose the legislators will work for free.
That's the number I was thinking, too.
Yeah.
But it means anything.
Right. I mean, I just think that that's something that they ask for. But I'm going to back up then as far as okay, so actually, no, I'm expecting from Karen some language on the rulemaking and how that should proceed, et cetera. So I'll wait to see that. And there's a few other changes that Katie noted. And we're going to have some more testimony this afternoon. Anything else from Karen or Stuart at this point? And you hopefully you can sit in and listen to the testimony this afternoon in case anything comes out of that as well.
Yes, happy to do that. I do have to hop over to House Healthcare if that's okay, but I can definitely,
we're good.
Just let me know when to be here this afternoon and I can make that work.
I think we are scheduled to have testimony starting at 1:30.
Great.
All right.
Nothing
Thank you
further
both.
for me.
All right. Thank you very much. Thank you both.
Thank you.
Bye.
So any input from the committee, at least at this point, as far as where we are and what we're trying to go? Any questions on where we are, where we're trying to go with this?
Moving forward.
Yeah, I mean, it's to keep the momentum going. That's the idea, and to be ready by the start date in July 24, if there's in fact a facility. And I know that there's corrections and institutions issues that they're dealing with. So.
Yeah, just wanted to reiterate what you just said, that it's not, the changes here are not designed to delay the process. It's just
right.
Slowing it down, maybe, but I mean, really just taking a deeper look at a very important specific part of, population of folks who would be potentially placed in this facility, making sure it's the right place for them where they can be treated with the care they need.
Right.
And so it is not a kicking the can situation. Just want to make that really clear.
Yeah, no, that's the intent.
Because I understand
we need
that
to get this
concern.
right. We need to get this right.
And I heard that from Karen too, the proper placement, basically. So that's definitely a big thing on their minds, I think.
So we have somebody from Human Services as well. Did you hear the question about developmental or intellectual disability? I don't know if you were.
No, sorry.
Okay.
Is there a new draft up? I'll take a look
Yeah,
at
it is.
that.
Yep, it's online. There's going to be some changes. We're going to move some entities from the working group to it must be consulted with because it's an unwieldy working group at this point. And we want to change that. Joe.
I just want to say, I feel like this is when I heard that this one starts July 1st, 2024 anyway, just to agree with Angela, it's like, it feels like we're using our time wisely here and trying to get it right, rather than sort of rushing some language into statute when the statutory language couldn't be used until July 2024 anyway. This allows us to actually develop really good statutory language that we can just adopt next session and then, have it ready to go. So that's why I support it.
Okay, so if you guys want a response, you're going to get the response. Don't act like this hasn't been looked at and not been dealt with for years. Just because there's a bunch of new people around here and stuff like this that haven't seen what's going on and the lack of efficiency and all this stuff and try to tidy up all this stuff. The bottom line is that people that need help are not getting the help. We have avenues, and as far as I'm concerned, you guys can say it whatever you want. You're trying to cloud it out as much as possible, and you're trying to, however this place works, whatever, And it's like, you know what? When you're in business for yourself, you go and you make decisions and you do them and you go and you tweak the process as needed. This is not this complicated. You guys want to make it complicated, so make it. And I'm not trying to make this personal or anything like this, but you know what? I am the minority here and whatever. So we have people out there that need help. We have avenues that they can get help. And we're not dealing with it. And we haven't dealt with it for many years.
Right. The administration hasn't put together the facilities that we need for the past.
So now you're going to throw the administration in there?
But here, listen to me on this. We're not running a business and we have to answer to various communities.
Maybe we should run this as a business.
And every disability rights community member, everybody has come, the stakeholders dealing with disability, developmental disabilities have come and said, don't do this. You haven't given it enough time. You haven't looked at it closely enough. And that's what we're trying to do here. And we're trying to get it right.
And I understand that, Mark.
We are trying to get it right instead of hurrying it along.
I understand that.
Apparently you don't.
But I do. My frustration is we've heard this for a long time. We have something on the table that we haven't had before.
This committee started hearing about it after crossover. We haven't dealt with Act 248 in the 8 years that Tom and Barbara and I have been on this committee. And it's a complicated area and we have to do it right. And we have to respect the people that this impacts. And that's what we're doing. And we're still going to have it open July 24, at least this committee is not going to be holding it up.
And in the meantime, we've still had a mental health, however way you want to use the words. We've had a mental health crisis that's only going to get worse for many, many years that we haven't really dealt with it as well as we could.
But it's complicated and it's multifaceted.
Right. And I don't disagree with that. And it's not in this committee, since nothing has come to this committee until after crossover in the past 8 years. And if there's been issues that needed to be brought to us from the administration, this committee's always been here. So now we're dealing with it and we're going to deal with it right and we're going to get it right. So in any event, we will, unless there's any other comments, we will adjourn until 1 o'clock. And we're going to look at S33, a new draft that has a couple other things in it, and hopefully be able to vote out S33 after the floor, which hopefully is not going to be very long.